We've recently completed a major review into the operation of the Real Property Act of 1886, a very major review that draws on our extensive consultation and our wide research. The South Australian Law Reform Institute carried out this review at the request of the state government.
As part of this review, we made 63 recommendations and 3 suggestions for reform. Combined, if implemented, these recommendations and suggestions should simplify the Real Property Act and make it easier to understand and make it easier to carry out real property transactions in South Australia.
As you can imagine, over time with an act like the Real Property Act 1886, it has been amended many times at many different points over the years by many different governments. As a result, there are many provisions that are in different places throughout the legislation. So in our report, we're recommending that the legislation be consolidated, redundant provisions removed, and placed in consecutive order so it's much easier to read for both the general public and the practicing profession. There are some small pieces of land throughout the state that have not yet been picked up as part of the Torrens title system. So in our report, what we're recommending is that there be a general set of provisions that will allow for any land that is still not Torrens land under the legislation to be brought within the provisions of the Act so that all of the protections that apply to any registered proprietor under the Torrens system will apply to all land throughout the entire state. Well, the Real Property Act 1886 contains definitions of both those interests that can be registered and therefore gain the protection of indefeasibility of title, and interests that can be caveated and therefore gain the protection that goes with notice being provided to others who may be dealing with the land. Some of those definitions are somewhat obscure, and therefore in our report we're recommending that there be general definitions that clearly set out all of those proprietary interests that can be registered and all of those interests that can be caveated on title. The new definitions will be clear in setting out those interests that can be registered and therefore gain the protection of indefeasibility of title, and those interests that can be noted on title and therefore give notice to others through caveating. And there will be one set of definitions for both registrable interests and for caveatable interests.
We also looked at electronic conveyancing or e-conveyancing and recommended that as many transactions as possible should be able to be carried out on electronic platforms. This would be particularly helpful to those in regional and rural communities who currently need to contract a third party to go down to the physical land titles office in order to carry out paper transactions. We also recommend having a granny flat interest as a distinct caveable interest. With rising housing costs and an ageing population, granny flat arrangements are increasing. By having it as a distinct caveable interest, people are able to have some legal protection over the money they've put into these arrangements. We also recommend increased public education around these arrangements and a model contract that people can use if they don't want to or aren't able to access legal advice. While SALRI recommends keeping most equitable interests off the register, we do recommend noting on a certificate of title whether a property is owned by a trust. This will be helpful in estate, family and bankruptcy matters, as lawyers will be able to see directly on the certificate of title whether a trust is involved instead of having to do further searches. SALRI recommends retaining the process of adverse possession for instances where land has been used by someone other than the registered owner for multiple years. Specifically, we would change the period from 15 years to 20 years. SALRI also recommends retaining the registered proprietor's effective veto over a claim of adverse possession and would encourage a public education campaign so that people recognise and understand that adverse possession is not the same as squatters' rights and people simply cannot go and take over another person's property. Fraud, especially misuse of power of attorney, was another large area of our report. SALRI recommends having a register of all powers of attorney, revocations of power of attorney and SACAT administrative orders, and for people to not be able to transact land unless the power of attorney is registered. We would also recommend that any transaction using a power of attorney has to be done by a lawyer or conveyancer, and for there to be increased training for lawyers and conveyancers around how powers of attorney can be misused and how to properly do identifications.
We are particularly grateful for the valuable input to this report of all the co-authors, noting the valuable scoping study conducted by Professor Paul Babby and Professor Peter Burden. Particular thanks to the members of the project reference group for their insight and input to this review.
We also thank and acknowledge the work of the many law reform students from the Adelaide Law School who assisted with this report. If you would like to read this report or any of our other reports, please head to our website.